Morning, Amanda. You're the first one to join, so I guess you must have set your alarm this morning.
Good morning.
Okay, can you see me, first of all? And then can you see the screens from the PowerPoints?
Like right now?
Yeah. I'll take that as a no. Hang on and let me change the screen setting here. All right, can you see the PowerPoints now?
Yes, sir.
And can you see me also?
Yes, sir.
Okay, so we're good. Let's see. Okay, I've got Richard, Colton, and Amanda so far. Okay, I got Hannah Garcia. Hannah Garcia and Braden Oglesby. So a total of 6 now. All right, now we have Amanda, Braden, Colton, Hannah, and Taylor.
Yeah, hell no. Boy, you got me fooled up.
Got Taylor. And there's Hannah. I recognize that laugh.
Yeah.
Is that good or bad?
I'm gonna have to mute my mic because I got like 3 dogs and a wash machine going. So yeah, I'm gonna have too much background noise going on.
All right. All right, so some people have cameras and some don't. I guess I don't have to see you, but you're gonna have to see the screen. Is anyone not able to see the PowerPoints at this point?
I can see the PowerPoint.
All right, sounds good. So far, only 7. We have 19 in the class. So that's unfortunate that we don't have more. So I hope it's just that people are oversleeping enough that they can't access for some reason. And I hope you're able to, looks like Yareem is getting in and Joshua. All right, so we just added Yareem and Joshua. And Joshua, I'm just going to take a quick roll here. Okay, so right now I have Joshua, Richard, Hannah, Colton, Braden, Yareem, Taylor, and Amanda. I'm missing Donovan, Dylan, Colby, John, Austin, Jacob, Vanessa, Kelsey, Mary Grace, Edward, and Naomi. What time is it? 8:04. We'll give it one more minute and then I guess we'll get started. Has everyone been having fun sleeping in? So it was hard enough, I suppose, to get up for 8 o'clock 8 o'clock class when you're here, but when you start getting used to sleeping until 10 in the morning, 8 o'clock comes pretty early, doesn't it?
Too early.
Too early. I guess you're not having any kind of practices, Hannah, at all?
No, all like our whole season.
It's completely through?
Yeah, we're upset.
So they say that this is going to go through April 5th, and we're supposed to resume class on April 6th, in-person class. I have my doubts on that. And one of the reasons I have doubts is because they've canceled graduation.
Yeah.
So that's a pretty strong sign that what they're going to not bring us back this semester. However, it is possible they bring us back, and the only reason they canceled graduation was because a lot of families out of state buying plane tickets and making arrangements they don't know if they should buy the tickets or not. So that's another reason to cancel it. So it is possible we could resume again. But if I was a betting man, I would say we'll probably be online the rest of the semester. That's nothing official. That's just my gut feeling. All right, see who else we have here. Total of 9. 1, 2, 3, 4, 5, 6, 7, 8, number 9. Okay, well, we got 8 students and me, so roughly half the class, a little less than half. Hopefully the others will join in. Were you able to print out your study guide?
I don't have a printer at home, so I wasn't able to do it, but I got it pulled up.
Okay.
Yeah, I have mine.
Well, that's good. I don't know if we should do my normal routine and have each person answer a question, or if I should just go through this. Probably it's faster just to have me go through it. So let's start with chapter 3 and question number 1. Just trying to watch this to see if any new people are trying to get in. It has what they call a waiting room. And it says people are in the waiting room, then I have to click to let them in. When, just pick someone, Joshua, when you tried to get in this morning, did it put you in something called a waiting room?
Yeah, it said that it was waiting for you to let me in.
I see, okay. So I just want to make sure I'm not somehow missing anyone. Okay, move right over here. All right. First of all, if you have any questions on anything before the test, I think everyone's got my cell phone number. I usually give it out, but if you don't have it, my cell phone number is 832-563-1150. So if you have questions on the test, feel free to let me know. Secondly, if you go to the announcement section of the Fundamentals of Criminal Law, under quizzes, you'll see what's called a dummy quiz. And when you click on that, you should try to attempt to take the dummy quiz. Doesn't mean you're a dummy, it means the system's a dummy. The quiz just has one question on it, and it's designed when you attempt to take that quiz to set up the correct browser. Canvas has a no cheat browser, and so you have to be able to set that up on your computer. So as soon as we get off today with the study session, if you haven't already done it, go ahead and take that dummy quiz, which sets up your browser to take the real exam on Thursday. So Thursday, 8 a.m. will be the real exam. Has anyone here tried to take the dummy quiz yet?
I did.
Yeah?
Yeah,
And did it work?
it did. Kind of cool.
So it sets up the browser, I guess. And really, basically what the browser does is it keeps you from accessing other websites during the test in an attempt to look for answers. So it's sort of an anti-cheating browser. It's not perfect, and if someone's smart enough, they could cheat. I'm just hoping if they're smart enough to figure out how to cheat, they would be smart enough to spend a few extra minutes studying for the test. So who knows? All right, so let's look at Chapter 3, question number 1. Does anyone have a difficult time seeing either me or the screen, the PowerPoint screen? All right.
No.
The main issue is to see the screen. I'm sure you're tired of looking at me after all these semesters. So, number 1, what is the definition of actus reus? That isn't on this crime, is it? Well, actus reus is the criminal. Hang on. There we go. Actus reus is Latin for criminal act or evil act. That's chapter 3, question number 1. Actus reus is Latin for criminal act or evil act. Number 2, what is the first principle of criminal liability? And that is the criminal act or the actus reus. Why is that? Because every crime has to have an actus reus. Not every crime, most crimes, but not every crime needs a mens rea, which is an evil mind, but every crime needs an evil act or criminal act, actus reus. And if I'm going too slow, feel free to slow me down here. That's the definition of criminal liability. Conduct that unjustifiably and inexcusably inflicts or threatens substantial harm to individual or public interests. I can hear someone talking, but I can't. If that's Braden, I can't hear what you're saying. Does anybody else hear someone talking? I hear what sounds like someone talking, but I can't hear what they're saying. Does anybody else hear that?
I can hear it. It just kind of sounds like background noise. I don't know.
Okay. All right. I just want to make sure I wasn't missing someone's question. All right. So then, what are the 3 analytical steps? Number 4, and that's on the slide here. First of all, is there criminal conduct? Secondly, is the conduct justified? And thirdly, is the conduct excused? And those 2 words, justification and excuse, we're going to cover in detail in chapter 5 and 6. So they will be on the next exam. Is there criminal conduct? Number 1. Number 2, is the conduct justified? Number 3, is the conduct excused? We're on chapter 3, question 4. So, number 5, what are the 5 elements of criminal liability? First of all, a criminal act. excuse me, criminal act. Number 2, a criminal mind. Number 3, concurrence. Number 4, attendant circumstances. And number 5, bad result. Not all are always required. You always have to have a criminal act, number 1, but you don't have to have a bad result in some crimes. For instance, burglary is a bad result, is a conduct crime. As soon as the man reaches his hand in the window, even if the window is already open and unlocked, he reaches his hand in the window in order to grab something to steal. He hears a dog barking, so he runs away. There's no bad result, but it's still a crime because burglary is a conduct crime. Murder, on the other hand, is a bad result crime. You can't have a murder without the bad result of someone dying. If the person doesn't die, it's not murder. So bad result is not required in all crimes, as an example. Let me check, make sure no one's in the waiting room. I don't see anyone. All right, do all crimes require a criminal act? Yes, every crime requires a criminal act. Number 7, do all crimes require criminal intent? No. As you recall, there's 4 levels: intentionally, knowingly, recklessly, and negligently. And then there's that 5th category of strict liability, which requires no fault at all. So no, all crimes don't require intent. You can be guilty of a crime even if you didn't intend to do it. And number 8, what is mens rea? Oh, here, okay. My lecture is getting ahead of my slides, so here's the answer to 6 and 7. Do all crimes require a mens rea? No, they do not. Do all crimes require attendant circumstances? No. What is an example of a crime requiring an attendant circumstance? And that would be DWI. We're on chapter 3, question 10. The attendant circumstance is while intoxicated. So DWI, the action, actus reus, would be driving. The mens rea, you don't actually have to intend to be intoxicated. As a matter of fact, most people I've arrested for DWI would say, I'm okay to drive, I'm not drunk. They don't realize it, so you're not required to have an intent. But if it doesn't require intent, it will require attendant circumstances. So driving is the actus reus, while intoxicated is the attendant circumstances. No intent required. Any questions so far? All right, number 11, which crimes require both an actus reus and a mens reus? And the answer to that would be serious crimes. But here's an example. These are examples: murder, sexual assault, robbery, burglary. These are serious felonies. So serious crimes or serious felonies will require both an actus reus and a mens rea. Number 11. Happen at the same time or very close in time. So if I get really mad at Braden, I think I should kill him. But then I relax, have a beer, life is good again. And then next year, Braden and I are buddies and we go hunting together and I accidentally shoot Braden. I'm a bad shot. Well, the mens rea, the intent to kill him from last year, will not be able to meet up with the actus reus, the actual killing of him this year. So this year, if it was accidental, they could charge me with negligent homicide for killing Braden, but not with murder if my intent to kill him was a year ago. So the concurrence means those two have to happen at approximately the same time. Number 13, what are the three elements of a conduct crime? Actus reus, mens rea, and concurrence. Looks like some people don't have your cameras on or your microphones on. That's okay for today. You need to have cameras and microphones working for the test on Tuesday. Okay, I've got a email coming in from Taylor Turner. He's having trouble connecting. All right, Taylor, you with us again?
Yes, sir. I don't know what happened. It just would not let me connect back in. It finally let me do it after like the 10th try.
Okay. All right. Well, if you're doing drug deals, you could just mute and then turn your camera off, and you'd be okay with that. You don't actually have to disconnect.
Well, first of all, you don't do drug deals at the house anyway, but yeah.
That's true, yeah. You don't want people knowing where you live.
Exactly.
I'm glad you're up to date on those kind of things. So we are on chapter 3, question number 13.
All right, yes, sir.
So a conduct crime is different than a bad result crime. And to have a conduct crime, you have to have an actus reus, an evil act, a mens rea, an evil mind, and a concurrence. So here the guy's breaking into the house. His actus reus is actually entering the house. His mens rea is intent to steal the television. And concurrence, they're happening at the same time. And that's a conduct crime. And as I said, if the window's unlocked so he didn't have to break it, and he's not even all the way in, he's just reached in his arm, he's already guilty of burglary at this point. If his intent is to steal something in the house, he's already a burglar, even if the dog scares him away, so he doesn't break the window and he doesn't steal anything. He's already a felon, a burglar at this moment. All right, then number 14, do all crimes require a bad result? And the answer is no. This is an example. Certainly if he actually does steal the TV, that would be a bad result. But if the dog scares him away, he still has committed a crime of burglary, even with no bad result. What then are, number 15, what are the 5 elements of a bad result crime? Actus reus plus mens rea. We had those in the conduct crime, but concurrence, causation, and criminal harm. So you have 5 elements to a bad result crime, and only 3 to a conduct crime. So applying those 5 bad result elements, we know murder is a bad result crime. You can't have murder without the bad result of someone dying. The actus reus is pointing the gun and shooting it. The mens rea would be intent to kill. Concurrent, they're happening at the same time. Causation, did that shooting of the gun or that mens rea cause the bad result or the criminal harm? With the criminal harm being death, and yes, so that is murder. 5 elements to a bad result crime. Only 3 to a conduct crime. So if you memorize that list, just think of the first 3 as being a conduct crime and having to add the last two elements to make it a bad result crime. Number 16, can thoughts be illegal or immoral? Well, thoughts can be immoral. We know that because that's what Jesus said. As the guys, if you lust after a woman, you've committed adultery in your heart. So every guy is guilty of that. Can thoughts be illegal? Well, thoughts can be illegal, but not by themselves. Thoughts are illegal only if they manifest themselves in actions. Jesus also said if you hate someone, you commit murder in your heart. We've all been angry. Probably we've all hated someone in our lifetime. Well, when we talk about can thoughts be illegal, they can, but only if they manifest themselves in an actus reus. And so if I said, I hate Hispanic females, that thought, if I think that thought in my head, that's not a crime. But if I say I hate Hispanic females and then I slap Hannah Garcia, which might be the last thing I ever do because she'll probably kill me if I did that. But if I did that, then my thoughts of hating Hispanic females would be manifest in an actus reus. And so simply hitting Hannah would be an assault, but hitting her with the motive of it being because I don't like Hispanic females would be a hate crime in which my thoughts had manifested themselves in an actus reus. That's the concept that we call manifest criminality. So 16 and 17 go together in question 17. Manifest criminality is the requirement that thoughts turn into acts before they can be punished. And I would never hit Hannah because she probably whipped my butt. Requirement that thoughts turn into acts before they can be punished. And that's because we can't see people's thoughts, but we can see their acts. And the law allows us to see the act and see some evidence of the motivation and assume that that was the thought. And number 18, can involuntary acts qualify as actus reus? And the answer is no. Your acts have to be voluntary. An example of involuntary act, which can't be actus reus, would be reflexes or convulsions, sleepwalking, automatism, actions under hypnosis. So we gave the example that obviously if you intentionally kick your doctor, that would be an assault. But if a doctor's testing your reflexes and he hits that little area underneath your kneecap, he hits a nerve and your leg kicks forward. So if the doctor is checking your reflexes and you kick him, it's not an assault because it's not a voluntary act. Convulsions, if someone has MS or some other illness where they go into convulsions and thrash around, as they thrash around, they may hit or kick someone, but it's not a voluntary act, so it's not an actus reus. I've never seen anyone who's been hypnotized. I've seen it in TV shows, but never in real. Has anyone here ever seen a hypnotized person? I've always been curious as to if you really can hypnotize someone to do something without their knowledge. On TV, they'll hypnotize someone and then they'll click their fingers and the person wakes up and has no idea what they've just done. I don't know how real that is. But in theory, if you could hypnotize someone to do something subconsciously, maybe even against their will, that would not be a voluntary act. All right, number 19. What are some examples of involuntary acts? Well, I guess we've already listed those. Reflexes, convulsions, sleepwalking, automatism, hypnosis. All right, let's see where we're at. Number 20, what is a voluntary induced involuntary act? Well, if an epileptic is driving and has a seizure, then the seizure is involuntary. So then his attorney would say, well, it's not a voluntary act. It's true that I had a seizure and crashed my car and killed someone, but since my seizure was not a voluntary act, I should not be held responsible. And a voluntarily induced involuntary act would mean, yes, it's true that the seizure itself wasn't voluntary, but your act of getting in the car and driving when you knew you were susceptible to seizures was voluntary. In Texas, if a person has a seizure, they must then be seizure-free for 6 months before they're allowed to drive. So the seizure was not voluntary, but you getting in the car and driving when you knew you shouldn't be because you have seizures was a voluntarily induced involuntary act, and you can be held accountable for the voluntary act of driving when you knew you were prohibited but for medical reasons. "21, what's the difference between action and status?" Action is what we do, status is who we are. Looks like about half the people are muted, that's okay. Looks like about a third of the people don't have cameras on. So again, if you're listening now, it's okay to not have a camera and be muted today. On Thursday for the test, you need to have both a camera and a microphone for Thursday's test. The test is at 8 a.m. I'll try to get it started about 5 minutes to 8 or so. All right, status versus action. Action, what we do, status, who we are. What can status arise from? Prior voluntary acts and immutable characteristics like gender, age, race, or ethnicity. I'll change that later. Number 2, it says no acts, but everything on there is an immutable characteristic. So since I don't have it on here now, I won't use the term immutable characteristic on the test. Can someone be legally punished for their status? Well, no. Recall Mr. Robinson was sentenced to jail for being an addict, which is a status, and the Supreme Court said no. Status, who he is, you can't punish someone for who they are, only for what they do. And so then after Mr. Robinson got off his charge, Texas lawyers said, well, let's make that same application to my client who got charged with public intoxication. And so he argued to the Texas court that my client was drunk. That is a status of being an alcoholic, therefore you can't punish him for it. And the court said, well, actually, we're not regulating a status with public intoxication, we're regulating behavior, because public intoxication says you have to be drunk in public. So we're not punishing the status of being an alcoholic, we're punishing the action of being drunk in public. If you're in your home, you can't be charged with public intoxication. Why? Because you're not in public. So public intoxication in Texas is an act rather than a status, and because it's an act, it can be punished. You know, Richard, if I had known you were going to be in this class, I would have changed that picture of you at the urinal there. I apologize for that. I shouldn't have called you out in front of the whole class. All right, can failure to act be an actus reus? Yes. If so, when? When you have a duty. So failing to act can be an act or an actus reus under the criminal law if you have a duty to act. Excuse me. So a failure to act can also be called an omission. What are the two kinds of criminal omissions? Two kinds are failure to report and failure to intervene. Failure to report would include a hit and run accident, failure to report child abuse, failure to report income on your tax return, failure to notify sexual partners that you're HIV positive. Under the category of failure to intervene, failure to prevent or injuries or death to people, like your own children. You have a duty to intervene to prevent injuries to your children or to an elderly person under your care. So if someone injures your child and you fail to intervene, that person would be guilty of injuring your child, and their actus reus would be, say, assault. Your crime would be a failure to intervene, and so your crime, your actus reus would be a failure to act, whereas theirs would be an act. What are three different ways that legal duties are created? Statutes, contracts, and special relationships. Statutes are laws saying you have to pay taxes, you have to report accidents, and you have to report child abuse. Police officer signs a contract with his department, creates a legal duty within himself to respond to crimes. Special relationships, parent and child is the most common. Doctors also have a duty to not harm their patients. And common carriers like buses and airplanes have a duty to their passengers. Because of that duty, that if the airplane crashes and it's Continental Airlines' fault, you can sue them because they've breached their duty to take good care of you. Well, your family will sue them. You'll be dead. All right, where are we at here? What is the difference between the Good Samaritan doctrine and the American bystander rule? Good Samaritan doctrine says you have a duty to rescue strangers. If someone's in trouble, you have a duty to rescue them. Only a very few states have that requirement. The American bystander rule, adopted in most states, including Texas, says if it's a stranger, you don't have a duty to help. So if someone attacked your own child, you would have a duty to help. But if you see someone being robbed, you see someone being beat up, although you may have a moral duty to help, you have no legal duty to help if it's a stranger. That's the American bystander rule, which applies in Texas. Number 29, can possession be actus reus? Yes. Oh, here, let me get by Mr. Pestinakis. And Mr. Oliver, or Miss Oliver, who brings men home and lets them die in their backyard. And Mr. Miranda, who likes to beat up his girlfriend's babies. Catherine Genovese, who was stabbed 3 times. American bystander rule said none of those people who saw it happen were bound to help her. She was killed on the 3rd time, if you recall. Okay, possession, 29. Can possession be an actus reus? Yes, it can. The argument is, well, it was in my pocket, but I'm not actually doing a criminal act. And the court's answer to that is, if you're in possession, then at some point you had to do a voluntary act to put it in your pocket. So yes, 29, possession can be an actus reus. 30, what 2 things are commonly charged in possession crimes? Drugs and guns. Could be other things like minor in possession of an alcohol, but the 2 most common are drugs and guns. What then are 31? What are the 2 main issues in possession crimes? First, possession, and second, awareness of the possession. Number 1, did you possess the drugs? Number 2, were you aware that you possessed the drugs? So if I'm talking to Yureen and I see the police come around the corner and I quickly put my drugs in her backpack, then Yureen now possesses the drugs, but she's not aware of the possession. That could be an issue. So let's talk about actual versus constructive possession. That would be number 1, possession. Actual possession is it's actually on my person. It's in my pocket, in my shoe, in the backpack that's on my back. So I have actual possession if it's in my pocket. Constructive possession is where I control the drugs, even though they're not actually on my person. They may be in my car, in my apartment, hidden nearby. And when police stop and talk to drug dealers, the drugs rarely are in their own pocket. Usually they have them hidden somewhere nearby, under a rock, under some leaves, under a nearby trash can. But the police have gotten smart and they start looking in those areas, so the drug dealers also get smart. And sometimes they'll take the money for the drugs and they'll say, okay, drive down to the next corner and talk to John or Juan or Jose or Demetrius or whatever. He'll hand you the drugs, and that way the person doing the drug deal isn't the same as the person who has the drugs, and it's harder for the police to catch him. Or he may have the drugs hidden in several different places, and you may say to the person after they give him the money, all right, see that tree over there? Just to the right of the tree, there's a rock. Under the rock, there's a bag of cocaine. And that way, if the police shake him down, he doesn't have the drugs on him. So actual possession would be in his pocket. Constructive possession, they're under his control, perhaps somewhere nearby. So remember, the first issue was possession. The second issue was knowledge of possession. So the second issue, knowledge of possession, brings us to question 33. What's the difference between knowing possession and mere possession? Knowing is you know you have it. So when I was talking to Yureen and I had drugs in my pocket, I knew they were there. That's knowing possession. When I see the police come around the corner and I very quickly put my drugs in Yureen's backpack, Yureen has mere possession. She doesn't know that she possesses it. So most states require knowing possession. If Yureen was then stopped and searched by the police and she had the drugs in there, she technically is not guilty because she didn't know they were there. The problem that you run into is when you tell the police, oh, I didn't know there were drugs there. Yeah, sure, right. Put your hands behind your back. And Yureen would probably go to jail for it because the police aren't going to believe Yureen that she didn't know she had drugs in her backpack. So it's a hard thing to prove. Which one does Texas require? Texas requires knowing possession. So backing up one slide. Are you there, Yureen? Yeah, I guess we've lost Yureen. I don't see her on the list. That's too bad. Anyway, backing up one slide, when I put my drugs in Yureen's backpack, does Yureen have actual or constructive possession? Well, she has actual possession because they're on her person. And then number two, the issue of awareness. Does she have knowing possession or mere? Her possession is mere possession. She doesn't know what's in the backpack. And that's the last question for this slide, this chapter. All right, let me close down chapter 3. There's Richard Clare's parking space. Go to chapter 4.
Dr. Hillman, since like most of chapter 4 was posted, I already got most of the answers for that. So do I have to stay to get all of them?
You don't have to stay. It'd be voluntary on your part to stay.
Okay.
I mean,
Well, yeah.
I recommend it, but no, if you got something else you got to do, I won't force you to stay.
Yeah. All right. Well, yeah, I already got most of chapter 4, so I'm gonna go ahead and go. I appreciate the help with chapter 3.
All right, have a good day.
All right, yes, sir. You too.
All right, number 4, what's the definition of mens rea, an evil state of mind? This is chapter 4, question 34. Mens rea is an evil state of mind. Number 35, the concept of blameworthiness. It's only right to blame someone that we can, to punish someone we can blame. And so in almost every crime, we want to say we won't punish you unless you are blameworthy. The only exception to that would be strict liability. Number 36, in what type of crimes must the state prove motive? And that would be a hate crime. Normally, the state doesn't have to prove hate. They don't have to prove why you killed someone, only that you killed someone. However, if they charge you with a hate crime, they also have to prove why you killed them. It has to be motivated by hate. The most common hate crime would be race or religion. So if, number 37, the state doesn't have to prove motive, why would they offer evidence of motive? And that is because motive can be used to prove intent. So if everyone sees me shoot and kill Amanda Wilson in class, they don't have to prove my motive, that the reason I killed her was because I don't like basketball players. They don't have to prove that, but they may go to my Facebook page and say, print out my Facebook page that says, I hate basketball players, I wish they were all dead, even though they don't have to prove that as a motivation. It's because they do have to prove intent. And so if I go to court and I say, I didn't intend to kill Amanda, I just was showing her my new gun and it accidentally went off. Well, now they're trying to prove motive to prove that there actually was intent and it wasn't just an accident. Also, motive can be considered in sentencing. People with a bad motive, the jury may decide to give them a longer sentence. That's when the state either needs to or wants to prove motive. Why would a defendant want to prove motive? If he wants to prove necessity. We use the escape from prison example. If he merely escapes from prison because he doesn't like prison, that's not good enough. But if he escapes from prison, for instance, to keep from being burned alive, that would be considered necessity. And so then the prisoner's motive for escaping becomes ultra important. Because if there is a necessity, then he's not charged with escape. What is the difference between, number 39, subjective fault and objective fault? Subjective fault, whenever you see the word subjective, it means, what were you thinking? You need to know that you are wrong for subjective fault. Objective fault means, what would a reasonable person believe? And so you could be incredibly stupid and not know that you can't buy a brand new 70-inch screen TV for $20 on the street corner. Subjective fault is if you knew it was stolen. Objective fault says, well, even if you didn't know it was stolen, the guy told you it wasn't stolen, but really any reasonable person would know a brand new 70-inch TV for 20 bucks in the street corner has got to be stolen. So objective fault says, even if you didn't know personally, a reasonable person would have known. Hang on. Yureen, are you back with us now?
Yes.
You got Kelsey Roberts with us now too.
Hello. Sorry.
It's all right, no problem. Let's see. So that's Kelsey, but Yureen, are you with us now again?
Yes, sir. Thank you.
All right. Well, let's see. We were making fun of you, Yureen, earlier, not realizing you weren't here.
Really?
We had, well, I say making fun of you, that's an exaggeration. We made you a druggie.
Oh,
And
man.
then I asked a question, you didn't answer, and I realized you're no longer with us, but that's okay. With your reassurance that you're not really a druggie, I'll take back everything I said, and I'll go on my Facebook page and apologize for everything I said bad about you.
I would appreciate that.
No problem, no problem. Okay, so where are we at? We are on chapter 4, question 39. We just talked about subjective fault means you personally knew what you did was wrong. Objective fault means, would a reasonable person know that they were wrong? There are, however, certain types of laws that require no fault at all, and we're on question 40. And those are laws that involve strict liability. If you have an old iPod, all worn out, maybe it's worth 25, 50 bucks, and you pay 200 for it, and you don't know it's stolen. The person who sells it to you says it's not stolen, but it ends up being stolen. If the law is written as strict liability, then you are in fact responsible. You are guilty of receiving stolen property. So strict liability requires no fault at all, and it's usually limited to very small crimes like Class C misdemeanors. Number 41, what is the only direct evidence of a person's state of mind? Confessions. If you tell me what you did or what you were thinking. That would be direct evidence. Yes, I robbed the bank. That's direct evidence of a confession. Yes, I intended to. Somebody's got some noise in the background. You might want to mute yourself if that's you. Did I intend to kill Amanda Wilson or not, or was it an accident? So if I confess, yes, I intended to kill Amanda Wilson, that would be a confession. That's direct evidence. Other than that, you have to look at circumstantial evidence. And so if I pull my new gun out of my pocket and I'm showing it to Amanda, it could be that it accidentally went off. I thought it was unloaded and it was loaded. And I shoot and kill her. I'm still guilty of negligent homicide, but in order to prove me guilty of murder, the district attorney has to prove I intended to kill her. And so they rely on indirect or circumstantial evidence. Something as simple as my facial expressions. Other people in the room can testify that my face was beet red with anger when I killed Amanda. Or in my defense, someone might testify, yeah, he had a very friendly demeanor. He and Amanda were both smiling and talking, and he was showing her the gun and it went off. And that's indirect or circumstantial evidence of what my intent was, what my state of mind was. So the only direct evidence would actually be a confession. How does a state usually prove state of mind? By what people do. You prove what people thought by what they do. It'd be easier for me to prove I accidentally shot Amanda if the witnesses said I was smiling when we were talking and the gun went off once. If I have an angry face and shoot 5 shots, it will be a little harder for me to try to say that was an accident if I pulled the trigger 5 times. All right, and number 43 is maliciously in the mens rea in the common law, the model penal code, or the Texas penal code. Well, we know it's not in the Texas penal code. Texas penal code is intentionally, knowingly, recklessly, or negligently. So maliciously is found in the common law. As you recall, the common law is created by judges over the centuries. And those judges used all kinds of different words to describe mens rea. Because of that, when the model penal code was written around 1960 as a model for the states to rewrite their penal codes, they limited it to just 4 words. Under the common law, which uses words like maliciously, what's the difference between general intent and specific intent? General intent means you intended to commit the criminal act. So in a murder, the general intent would be I intended to pull the trigger. Specific intent would means I intended to commit the criminal act and to cause the harmful result. So murder would be a specific intent crime. They have to prove 2 things under the common law. First, that I intended to pull the trigger, and secondly, that I intended to cause the death of Amanda in this case. So shooting a gun inside the city limits where it's prohibited would be a general intent crime. I intended to commit the criminal act of shooting a gun inside the city limits. Murder would be a specific intent. I intended to pull the trigger and I intended to cause the death. And as you recall, since Texas doesn't use the common law, there's a much longer discussion on common law in the textbook that I decided to skip for purposes of our class. So since we don't have that huge common law list, number 45, what are the 4 levels of mens rea in Texas? From highest to lowest: intentional, knowing, reckless, and negligence, also called criminal negligence. Okay. I don't see it on here. That's fine. All right, number 46. What is the definition of intentional? It would be good for you to know these 4 definitions. I know they're a little bit lengthy, but these 4 words comprise all of mens rea law in Texas. Intentional, conscious objective or desire to engage in the conduct or cause the result. So in a conduct crime, if you intend to commit a conduct crime, it's your objective to engage in the conduct. Burglary, it's your intent or objective to enter the building to steal something. Intentional for a bad result crime is it's your conscious objective or desire to cause the result. For me to be charged with intentionally killing Amanda, the state has to prove it was my conscious objective or desire to kill the result, cause the death of Amanda. That's intentional. Section 6.03a, I won't test you on that. Moving on to 47, knowing. You're aware of the nature of your conduct or that the circumstances exist, or you're aware that your conduct is reasonably certain to cause the result. So intentional, it's what you wanted to happen. Knowing, well, you knew it would happen. All right, keep checking my phone because some people have been losing their contact and they send me a message telling me they can't get back in. At this point, I have Braden, Amanda, Colton, Hannah, Joshua, Kelsey, Richard, and Yareem. Is anybody online that's not listed here? Okay. Number 48, what's the definition of reckless? Aware of, but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. And that act is a gross deviation from the standard of care that an ordinary person would exercise. Of all 4 of the words, that one has the longest definition. I've underlined the most important words. Reckless, you're aware of, then you disregard that substantial and unjustifiable risk. Criminal negligence, number 49, says you ought to be aware of a substantial and unjustifiable risk, and your failure to perceive the risk was a gross deviation from the standard of care that an ordinary person would exercise. Again, the most important words being underlined. So people often confuse reckless with negligence. Backing up and now just concentrating on the underlined words. Reckless, you were aware, but you disregarded. Basically, you're aware, but you don't care. Criminal negligence, you weren't aware, but you should have been aware. And the fact that you weren't aware was really, really stupid. So reckless, aware, and disregard. negligence, not aware, but you should have been aware. And negligence is a lower standard. Any questions from anyone on those 4 levels?
Yeah, Dr. Hillman, on those 2 that we just talked about, would that would only be aware of the risk, right? Not aware of the crime, because if they were aware of the crime, that would put them back in knowingly, correct? Or intentionally?
That's right. This guy on the motorcycle, he doesn't know. Well, first of all, he doesn't intend to hurt anybody. He's just showing off for the girls. And he doesn't know someone's going to get hurt. But he is aware of the risk, and he's disregarding the risk. So he knows if he's standing up on his motorcycle, driving fast down a crowded street, that he could lose control, crash into the crowd, and hurt someone. So, yeah, that's the risk. He doesn't, it's not an issue of whether he knows that there is a law that says you can't drive recklessly. The question is he aware of the risk? Certainly he's not aware that what he's doing will result. So if he's aware, if for instance there's a wall of children 20 feet ahead of him and he continues like this, then probably you can charge him with awareness, which is the 2nd level, with knowing, because then he's aware that his conduct is reasonably certain to cause the result of hitting the kid. So if he's driving 60 miles an hour, there's a group of kids right in front of him, I think they could charge him with knowing, because he's aware that his conduct is reasonably certain to cause the result. In this case, everyone's standing in the sidelines. There's nobody in the street. He's going 60 miles an hour down the middle of the street. He's aware of a risk. He's not aware that he's reasonably certain that he'll crash, but he's aware of a risk of crashing. He disregards that risk. It's an unjustifiable risk, and it's a gross deviation from what an ordinary person would do. So, excellent question, Colton. Because there's this one, knowing also uses the term aware. But this is going to require a reasonable certainty that is going to cause results, the knowing. The awareness and reckless is just awareness of an unjustifiable risk. Good point. The word aware is part of both definitions. Any other questions on these 4? I think I mentioned it in the class before, but we're in the process of putting together a mini-term class on Texas Penal Code. We're not going to offer it this mini-term. By the way, if you haven't registered, registration has started this week, so everyone should be registering. And your advisor should have sent you an email with directions. As they're saying, as of now, they're saying we are going to have May mini-term classes. Don't count on it. It's possible those could be canceled too. It just depends on how the curve goes. We're trying to flatten the curve, and that's why we have these no contact rules. Anyway, I digress. I guess what I started to say was this Fundamentals of Criminal Law deals a lot with the philosophies of the law and the background of what these words mean. When we get into the Texas Penal Code class, it'll be a lot more practical. You'll be set up with criminal scenarios, and you will be either the police officer on the scene or the assistant district attorney, and you'll have to decide what to charge the person with. So there's a lot more hands-on and practical use of the Texas Penal Code when we have that class, and it will probably be offered next spring. All right, moving on. Number 50. What one thing is required for a strict liability crime? Does anyone know that before we get to it? Strict liability doesn't require blameworthiness, but every crime requires something. voluntary action. So your actus reus is your criminal act, and it has to be voluntary, right? So if strict liability does not require any kind of mens rea, any kind of evil mind, then it does still require that one thing, the voluntary act. So it can't be based on a reflex or automatism or sleepwalking, hypnosis. You have to have some kind of voluntary action. If you decide you capture a wild mountain lion on your next trip to Colorado and you bring it home and put it in your backyard, you put it in a really strong steel cage and you lock the cage so it can't possibly get out. Then some teenagers come and they want to play with your mountain lion, so they sneak in while you're at work and they cut the lock on the cage. The mountain lion escapes and kills a child. Well, guess who's liable? You. Because keeping a wild animal like a mountain lion or a tiger or something like that is a strict liability crime. So even though you did absolutely nothing wrong, you can still be held liable for keeping wild animals on your property. All right, concurrence. There's two different kinds of triggering in conduct crimes versus bad result crimes. Mens rea must trigger actus reus in a conduct crime. That's number 51. So here's burglary. It's a conduct crime. The mens rea, that this man's intent to steal, must trigger his actus reus, his breaking into the window. These are issues of concurrence. Now, conduct crimes is not the same as a bad result crime. So when we talk about concurrence in a bad result crime, we say the mens rea must trigger the cause in a bad result crime. So Kelsey wants to kill me. She drives towards me. She has a mens rea of wanting to kill me, intending to kill me. And she's got an actus rea. She's driving towards me. But before she gets there, Amanda drives up and kills me instead. So Amanda has a mens rea of wanting to kill me, an actus reus of driving towards me, and her mens rea is triggered the cause, which is hitting me and causing my death. But Kelsey is not guilty of murder. Why? Kelsey had a mens rea of intending to kill me, but did her mens rea trigger the cause of my death? Actually, it didn't. It was Amanda that ended up killing me. So since this is a bad result crime, Kelsey is not guilty of murder, because even though she had a mens rea and an actus reus of driving towards me, her mens rea didn't trigger my death. What could Kelsey be charged with? Since Amanda was the one that ended up killing me, Kelsey could be charged with attempted murder for driving towards me in an attempt to kill me. And of course, if Kelsey and Amanda are working together as accomplices, they both could be charged in my death. But we don't cover that till a later chapter. We'll talk about accomplices. So 50 and 51, excuse me, 51 and 52. 51, mens rea must trigger actus reus in a conduct crime. And 52, mens rea must trigger cause in a bad result crime. It seems a little bit confusing, mostly because we're using these Latin terms, but if you think through it, just common sense, it makes sense. Now we talk about different kinds of causes. Number 53, what's the definition of cause in fact? The defendant's act triggered a chain of events that ended in a harmful result, also called but-for cause. When I push down the first domino, 1,000 dominoes fall down and the last one falls down. That's a cause in fact. I caused the last domino. So if I'm charged with pushing over the last domino, the cause in fact is, yes, I did. Is there an intervening cause? Yes, the intervening causes is 999 other dominoes fell. What's the definition then of legal cause? Legal cause is a judgment that it's fair and just to blame the defendant for the result that he caused, also known as proximate cause. So in court, you have to prove proximate cause. And as you recall, if you watched the video, we talked about this accident. One person swerved on the northbound side without signaling their turn, and that caused an 18-wheeler to lose control, and that caused this whole chain of events. And then on the southbound side, you had rubberneckers looking at the accident, and that caused other accidents. So the person on the northbound side who failed to signal the lane change, are they a cause in fact of the accidents on the southbound side? Yes. If the first person on the northbound side had signaled a lane change, then the trucker would have seen it coming. None of this would have happened. So the person on the northbound side is a cause in fact of the accidents on the southbound side. But for the fact that they didn't use their blinker, the accident on the southbound side would not have happened. But are they the legal or the proximate cause? Is it fair to charge the person driving the red car on the northbound side who failed to use their turn signal? Is it fair to charge him with the accident on the southbound side, which was caused by rubberneckers? And the court would probably say no, that it's not a proximate cause of the rubbernecking accident. There was intervening causes. Stupid people watching the accident instead of watching the road. So probably the court would not hold the northbound driver responsible for the southbound accident. They'd say it's not fair. There's too many other intervening causes like rubberneckers that's causing that accident. So the person on the northbound lane would likely be held accountable for the northbound accidents, but not the southbound accidents, if that makes sense. An intervening cause is something that interrupts the chain of events or substantially contributes to the result. And so the southbound traffic rubbernecking would be an intervening cause that would take the but-for cause, the cause in fact, and say, you know what, it's not fair because of the intervening causes of the rubberneckers. It's not fair to charge a northbound driver with the southbound accident. So the court would say because of the intervening cause of the southbound traffic, we're not going to say that there's proximate cause for the northbound driver. Questions on that? Number 56, what's the difference between causation and correlation? Causation means one thing actually causes another. Correlation just means two things rise or fall or happen together. We use the example of ice cream. In the summertime, more ice cream is sold and there's more crime. It doesn't mean that eating ice cream causes crime. The heat causes more ice cream to be eaten, and the heat also causes crime to go up. But ice cream consumption and crime are only a correlation. One goes up at the same time the other bit goes up, but it doesn't mean there's a cause involved. Number 57, is ignorance of the law a valid defense? And the answer is no. Ignorance of the law is no excuse. If it was, everyone would just claim ignorance. I had no idea that was the law, and you get off of it. So ignorance of the law is no excuse. What about mistake of fact? Is that a valid defense? And the answer is yes, it can be, because the liability depends on what you believe the fact to be. And what we said is a cat is keeping you awake in the alley, so you shoot into the alley to shoot the cat, and you end up shooting a homeless person. You're not guilty of murder if you didn't intend to to kill the homeless person. But your liability depends on what you believe the facts to be. So you could be charged with cruelty to animals if you actually shot the cat. You could be charged with criminally negligent homicide because the facts as you believe them to be were that there was a cat out there and you shot into the darkness not really knowing what was there. And so here, a mistake of fact, you didn't know a person was there, so you can't be charged with murder. Why? Because you didn't intentionally or knowingly kill a person. But you either recklessly or negligently killed a person. Probably negligently. You weren't aware the person was there, but you should have been aware. Before you shoot into the alley in the darkness, you should be aware of what's there, what you're shooting at. So probably that person would be charged with criminally negligent homicide. Could they be charged with reckless homicide, one step up, manslaughter? Well, were they aware of and then disregarded a substantial risk? Maybe. It'll be up to the DA to decide whether that should be manslaughter, which requires a reckless standard, or criminally negligent homicide, which requires a negligent standard. All right, mistake of fact, does it mean you have no criminal liability? No, you do have the criminal liability for what you believe the facts to be. So if I thought that I'm mad at my neighbor and I thought I'm going to shoot up my neighbor's car, and so I point a gun at my neighbor's car and shoot, that would be criminal mischief. If it turns out my neighbor was sleeping in his car because his wife kicked him out of the house and I end up killing him, the mistake of fact would be I didn't know he was in the car, so I can't be charged with murder, but I can be charged with the facts as I believe them to be, which would be criminal mischief for shooting the car and possibly criminally negligent homicide for shooting in the car, if the jury would believe that I should have been aware someone was in the car. I guess that's our last question. Are there any questions on any of these questions we have or anything to do with the test? The test is 8 a.m. on Thursday. As soon as you hang up from this study session, you need to go to the quizzes tab on your criminal law canvas and look for dummy quiz. You then take the dummy quiz. It only has one question. You do that today, and that will take you through the steps, the process of setting up the special browser that Canvas has for taking a test. That browser is designed as an anti-cheating browser. It will prevent you from accessing other materials, other websites, other materials on your computer while you're taking the test. So make sure you do that as soon as you hang up here. It'll only take you about 5 minutes, and that way you'll be ready Thursday morning for the test. Richard, any question?
It's about my schedule for next semester. We made it yesterday. I was just looking at it, and it's 2 statistics classes.
All right. Well, let's once we hang up with this, why don't you call me on the cell phone, and we can look at that again.
All right.
Braden, any questions? Colton, any questions?
No, sir, I'm good.
Kelsey, any questions? Ureem, any questions?
No, sir.
All right. Again, those of you joined late, my cell phone number is 832-563-1150. Feel free to call if you have questions. And if you have any friends that missed this study session, make sure you remind them that the test is Thursday at 8. Then next week, I'm sorry?
It's right at 8 tomorrow.
I'm sorry?
We have to take the test right at 8 o'clock tomorrow.
I'll open it up at 8. I guess we'll probably have it open from 8 to 10. It'll probably take you 30 minutes to take it. So if you got here a little bit later, probably all right. Why? Well, call me if you have any other issues on timing of the test. Any questions from anybody? All right, well, I guess we'll end this session. Call me on my phone if you got any questions. Thanks for joining us.
Thank you.
Thanks.
All right. Thank you.
All right.